Hello everyone, my name is Anna and I'm a volunteer at the Baytree Centre. I'm also a solicitor specialising in employment law. Today I'm going to give you a short overview of some of the key rights which may apply to you at work. I cannot provide you with advice relating to your specific circumstances, but hopefully this overview will help you to know how you should expect to be treated at work and what you might do if you feel you are not being treated properly. So let's start with the basics. Working people in the United Kingdom benefit from many rights. These rights come from two main places. First, the contract or agreement between the person giving the work and the person doing the work. It's generally best if this is put in writing. But if you don't have a written contract, don't panic. An oral contract can also be binding. The second source of employment rights are the laws that are made by Parliament and the courts. To know which of these laws applies to you, you need to work out your employment status. Now, this is not always an easy question, but generally there are three options. 1, you may be an employee. In this case, the person giving you the work will have a high degree of control over what you do and how you do it. Employees benefit from the most rights and protections. 2, you may be a worker. In this case, you'll have slightly more flexibility and control over what you do, although you must still do the job yourself. You can't send someone in your place. Workers have some rights, but not as many as employees. Finally, you may fall into category 3 and be self-employed, that is, you'd work for yourself. Here, you'll have a great deal of flexibility over what you do and how you do it, but you'll also have very few rights. And now for my first red flag. What you must remember is that it is the reality of the situation that matters, not just what your boss says or writes on paper. To deprive you of your rights, some employers may say that you are self-employed when you're actually an employee or a worker. So do look out for that. Now we've covered the basics, let's have a quick think about paperwork. As I said, there's no legal requirement for you to have a written contract. An oral contract can also be binding. However, if you're an employee or a worker, you are entitled to a written statement of the particulars of your employment. This should include key terms, some of which are listed up on the screen. The second very important document is the payslip that you should receive each time you're paid. The payslip should set out the amount you're being paid on that occasion and any deductions from it, such as for tax, or perhaps if you were overpaid previously. Now here's another red flag. There are only very limited circumstances in which an employer can make deductions from your pay. So if your pay is less one month than you expect, it may be worth taking advice as to whether the deductions that have been made are legal. Now, before we move on, I want to touch briefly on the topic of changing terms of employment. In these current very uncertain times of the coronavirus, many employers have sought to change the terms that were agreed with their employees. The basic point to remember is that a contract can generally only be changed if both parties agree to change it. Even where the contract contains what is known as a flexibility clause, this should only be exercised reasonably, so you may wish to take advice and consider pushing back if your employer threatens to make a change that you're not comfortable with. If you do agree to a change, it's generally helpful for this to be confirmed in writing to reduce the scope for potential future disagreement. Right. So now let's take a look at a few of the many rights that you have as an employee or worker in the United Kingdom. Again, I would stress that each of these rights is complex and will depend on your specific circumstances. I can just provide an overview. So first up, the best bit, the money. Employees and workers in England should be paid a minimum hourly rate for their work. The rate will depend on their age, and it changes in April each year. The current minimum wage for a person aged 25 years or older is £8.72 per hour. Now, as we all know, it's important for mental and physical well-being that we have sufficient time off work. The rules around working time are again very complicated, but I've set out here the basics. Employees are entitled to a minimum of 5.6 weeks paid holiday each year. That's 28 days if you work a 5-day week. Of course, if your contract states that you're entitled to more than that, then the higher amount will apply. The government's issued some specific guidance regarding taking holiday during the coronavirus period, and I've included a link to the government's webpage on that topic on the slide. In addition to holiday, you're also entitled to rest breaks, both during the working day and between working days. And finally, you shouldn't be required to work more than 48 hours per week on average. Now let's just take a moment to consider a couple of topics that are high on everyone's agenda during the current coronavirus crisis. If you're not well enough to go to work, you should check the employer's sickness absence policy if they have one, and make sure that you comply with their notification requirements. Generally, you'll be required to inform your employer as soon as possible. Some employees will be eligible for statutory sick pay for part of their sickness absence. To qualify for this, in normal times, you must have started work with your employer, you must be sick for 4 full days or more in a row, you must earn more than £120 a week, and you must not fall within certain specified exclusion categories. You should also check your contract of employment to see if you're entitled to be paid more than statutory sick pay. Now, the rules regarding sickness absence and pay are slightly different when it comes to coronavirus, so you should check the government's website for the latest position. Again, I've put a link on the screen. On a similar subject, employers have duties to protect the health, safety and welfare of their employees. Again, their duties during the coronavirus crisis are the subject of changing guidance from the government, and so I've included another link so that you can check the latest position. Right, stepping away from coronavirus and on to family-friendly rights, which it's important to note for the most part only apply to employees. Pregnant employees are entitled to time off to attend antenatal appointments. Parents-to-be and new parents are entitled to time off around the birth or adoption of their child, and some, but not all of them, will be entitled to be paid during maternity, paternity or adoption leave. As an employee, you also have a right to take a reasonable amount of unpaid time off to do what's necessary to deal with emergencies involving your dependents, such as your children or parents. Don't forget, though, you must let your employer know what's happened and how long you think it will last as soon as you can. After you've worked for your employer for 6 months, you also have the right to request flexible working, and after 1 year, unpaid parental leave. So I hope those family-friendly rights are all clear. And now we move on to a very fundamental right in UK law. As an employee or a worker, you have the right not to be discriminated against on the grounds of certain characteristics. These are sex, marriage or civil partnership status, pregnancy or maternity, disability, race, religion or belief, age, sexual orientation, or gender reassignment. There are various types of discrimination. One example is direct discrimination, which occurs when you're treated worse than someone else because of the relevant protected characteristic. So, for example, you're not promoted because you're a woman. Another type of discrimination is harassment. Now, harassment occurs where someone behaves in a way related to a relevant characteristic, and that behaviour is offensive to you. For example, your colleagues make jokes and rude remarks about people who wear headscarves. You also have the right not to be treated worse or dismissed because you have blown the whistle, which means you've reported some kind of wrongdoing. An example of that would be if you found out that the company that you work for hasn't been paying taxes properly, and you report this to your boss. You cannot then be sacked as a result of your having made that report. Now, unfortunately, things can go wrong in the employment relationship. Where you as an employee have a complaint against your employer, this is called a grievance. Where your employer has a complaint against you, this is generally referred to as a disciplinary matter. In either of these situations, grievances or disciplinaries, your employer should follow its own specific procedure. Or, if it doesn't have its own specific procedure, then the ACAS code sets out the minimum fair procedure. And as you would expect, this includes, for example, the duty for the employer to give you proper notice of the allegations against you. You must be given the opportunity to put your side of the story, and you must be allowed to appeal against any decisions. You should also be allowed to take a companion to key meetings, and key information must be provided to you in writing. So what if your differences can't be resolved? What are your key rights at the end of the employment relationship? Can your employer just sack you? Well, generally speaking, no. Unless you've done something very bad, your employer must give you the notice that you are entitled to, or they must pay you instead of giving you your notice. I've put the minimum periods of notice on the screen, and if your contract contains a longer period of notice, then you will be entitled to that. In addition, if you're an employee and have been employed continuously for 2 years or more, you have the right to a written explanation of the reason for your dismissal, and your dismissal must be fair. To be fair, the dismissal must be for one of the 5 potentially reasons that are listed on the screen: redundancy, conduct, capability or qualifications, illegality, or some other substantial reason. And it must be reasonable in all the circumstances, and the employer must have followed a fair process. So now I've shared with you a very high-level overview of some of your rights. I expect that you're thinking, that's all fine, but what do I do if my employer just doesn't respect those rights? Well, broadly speaking, there are 3 courses of action available to you where things have gone wrong. The first is to simply discuss the matter with your manager. It may be that there's been a misunderstanding that can be easily resolved. If that doesn't work, you may consider raising a grievance, as discussed earlier. Ultimately, you may wish to take a claim to an employment tribunal. But before you take any of these steps, I would suggest that you take specific advice relating to your circumstances and the potential next steps for you. I've suggested here 3 organisations that I think could help you. They are ACAS, which is an independent body that provides advice and conciliation services to employers and employees, the Citizens Advice Bureau, and the Brixton Advice Centre. These bodies all have lots of information on their websites, and you will also find their details of their advice lines and clinics, which will be able to advise you on your own specific circumstances. In order for them to advise you properly, before you make contact, try to gather all the relevant paperwork, including your contract, any letters from your employee, any relevant policies and procedures from your employer. These might be contained in the staff handbook, for example, your pay slips, and the like. And the final red flag that I would like to leave you with is just to warn you that employment tribunals have very, very strict time limits, and often these are just 3 months minus 1 day from the date on which the action that you're complaining about occurred. So if you think that you may wish to raise a claim, you should take advice and take action as soon as possible. Well, that's it from me. I hope that you have found this talk helpful. Thank you very much for listening.